in this
Well,
country.
in the 11th century. Oh, sorry, you want the short version? My grandparents were Armenian.
Welcome to our VASA Law Immigration Minutes podcast, where we focus on giving you tips to navigate complex U.S. immigration laws without the politics. Welcome, social media friends and family. Today we dispel the myth that it's easy to get U.S. citizenship by simply filing and filling out a form. Also, I will discuss 5 essential principles to succeed in naturalizing to a U.S. citizen. I've been practicing U.S. immigration law for over 25 years, and my colleagues and I are surprised at how many people have been led to believe that it's easy for U.S. citizenship to be achieved. We want to dispel that myth and help non-citizens avoid frequent landmines in the naturalization process. The U.S. government scrutiny has only become more rigorous throughout the years, and filing for citizenship is akin to inviting U.S. Citizenship and Immigration Services to audit one's entire immigration history from beginning to end. The N-400 is loaded. It's a loaded form because even checking one box could unravel the entire status in the United States. The way the immigration path works before applying for citizenship kind of looks like this. First, someone enters the United States with a temporary or permanent visa issued by the Department of State. Then individuals are screened by U.S. Customs, Border and Patrol at the port of entry to the United States. Once granted entry to the U.S., a non-citizen is now under the jurisdiction of USCIS. Now, when naturalizing, immigration officers review the entire record across all agencies chronologically, even if the applicant has been a U.S. permanent resident for several years. Any errors, even by the government, at no fault of the applicant, can affect the outcome of a naturalization application, and this makes a big difference in remedying adverse issues. In the case of employment-based green cards during naturalization, one is often asked detailed questions about the employer. Individuals rarely know much about the employment-based I-140 petition filed because they have relied on the employer's lawyer. Our attorneys have had clients come to us over the years with their entire status unraveled due to a shaky U.S. employer. And when he or she applied to be naturalized in the U.S., it triggered removal proceedings and a notice to appear in the U.S. Immigration Court. I'll now explain the 5 essential principles to succeed in naturalizing to a United States citizen. First, when filing for citizenship, review your passport and request a FOIA record of the entire travel history. FOIA is the entire immigration file, and it helps you to calculate for presence in the United States, which is tricky. And one has to balance continuous residence in the United States versus physical presence. An applicant may meet the continuous residence requirement, but not the physical presence, and be denied citizenship. Second, the most common reasons for denial of citizenship are the following: failure to pay 245I fees, criminal immigration consequences, character, not paying taxes, and previous suspected immigration fraud. Let's briefly review these reasons. If an applicant is grandfathered under 245I and received his permanent resident status without paying fees, when applying for naturalization, the fee request will be triggered and can result in denial of one's citizenship. Criminal charges, even if vacated or dismissed, can result in denial of citizenship based on 2 grounds: character and the crime makes the applicant removable or inadmissible to the United States. Also, if you've not paid taxes, discuss this with immigration counsel in addition to a CPA regarding your options. Finally, marriage fraud. If suspected during the N-400 review process, has severe permanent consequences. Next, we'll discuss good moral character. Good moral character is required and is separate from anything to do with criminal immigration background. The typical period of review is a 5-year window, with the period tolling at the issue date of one's green card. However, USCIS in many circumstances extends its review well beyond the 5-year window and can question character going back decades. Putting together a good character support plan with Immigration Counsel is key, especially if at any time there has been an issue with crime, taxes, substance abuse, such as DUIs or DWIs as it's referenced in many states, multiple traffic violations, etc. The fourth point is if you have filed an I-751, this only applies to people who are married. Removal of conditions, that application after 2 years is required to remove the conditions off of your green card. If it has been pending well outside USCIS processing times, you are eligible to file for naturalization. However, USCIS will combine both applications together, the N-400 and I-751. So at the time of interviewing with the immigration officer, he or she will dive heavily into the authenticity of one's marriage, especially if the marriage is terminated. So one must be prepared. The fifth and final point, inadmissibility issues are also reviewed at the time of application to become a U.S. citizen. The inadmissibility issues include a long list of bans not discussed here that may require a waiver. So those have to be reviewed extensively before you apply for naturalization. Well, that's it for now. If you apply the above principled approach to the naturalization process, the process can in fact be easy, as one will avoid surprise landmines and can achieve citizenship in the United States. Thank you for listening to this presentation of Wait One U.S. Immigration Minute. You may contact our lawyers at info@becapitallaw.com, and our contact information is listed below for your convenience. Until next time, take care and thank you for listening.